Real talk. No bull. Real talk. We're putting it all on the table. You know what to do.
Everybody, my name is Tim,
Braden.
and this is Real Talk No Bull podcast. We got episode 52 tonight,
52.
and we have
Look at you.
look at you.
Oh, we've been rhyming it every other week.
Look at you.
Look at you. 52. Look at you. Look at us.
Yeah, look at us. Yeah, and we have a special guest on the podcast tonight, Roger Saberi. Is that how I say it?
Well, actually, my last name is Poed.
Okay.
Oh,
I'm
you're
the
way
legal-
off.
Wow.
I'm the legal practitioner director of Transitional Legal.
Yep.
It's a law firm. I've been doing family law for about 10 years now. So lovely to be here, guys.
Yeah, no, awesome, man. Thanks
Yeah.
so much for coming on. Yep, it's a pleasure to have you, mate. Like we were just talking before the podcast, the family law and the DV sector is a bit of a hot topic when it comes to, I guess, well,
The
yeah.
community.
Yeah, I mean, and because, we're heavily influenced by the dads community, we see a lot of dads going through this sort of stuff. Obviously, we only really have one side of the story here, which there is always two sides to the story. But we see a lot of dads going through the hard stuff. So, and it's not to say that the mums don't either. I mean, everybody, everybody has
They're all affected by it.
that's right. They're all affected by it.
That's it.
Yeah.
But
Yeah.
don't go too much into it because that's some of my questions.
Yeah. Yeah. But we're going to crack on with everybody's favorite segment just to get the conversation started.
What ripped your undies?
I'm going first because I've got two to make up for my shit ones over the last couple of
All
weeks.
right. Knock it out.
AI.
Yeah. Okay.
AI. I love Claude and I love ChatGPT. Don't get me wrong. But I won't stand for it in the music industry. I feel ripped off. I've been listening to that Raven Law only to find out that it is all AI. The beats, the voice. Remember how I said to you, Jared, the other day that song sounded like Raven Law? Because it fucking was. So that ripped my undies. I am a big music person and I get attached to it.
It's a fair point.
Yeah.
It's a very fair point.
Like, I found myself really going to a song the other day. I'm like, of his, I was like, fuck, that hit hard. The feelings that he must be feeling, fake. Couldn't believe it. I was so annoyed, and my kids were gutted too. But that's what number one. And two,
I might have to call you Marlon from now on.
what's Marlon?
You're a big fish.
Oh, yeah, absolutely. Yeah, that really ripped my undies. And the other one is spreadable butter that isn't spreadable.
Oh my God.
Like I wake up in the morning, I like to have my raisin toast with butter.
Yeah.
And it rips my bread
Like,
and my undies.
Well, I guess, like, I don't know, like if I think back to my Nana's house, right? She used to have the butter on the bench underneath the butter thing. It didn't live in the fridge
Oh,
because it would go rock solid. And so it would live on the bench. And it was very nice and spreadable.
you can't do that here though.
But it was like on like a little butter plate with like a little cover over
Oh,
the
no.
top of it.
Oh, yeah, like I bought it was like, like a wog family, so I get that, but
Yeah.
here if you have your butter out in summer, it's gone. So it's a liquid.
Yeah, well, yeah, I understand that.
But yeah, no, I agree. I
Yeah.
like it.
Yeah,
I like
yeah,
it. But
yeah.
yeah, maybe my fridge is up down too much.
What about like, did you buy the spreadable butter? Or
It
is
should
like
all be
a-
buddy spreadable.
Or is it like a block of butter?
Oh
No.
my
It's in the
God, I
container.
can't believe it's not butter.
Yeah, absolutely. And that rips my undies.
Yeah.
It does.
Fair enough.
It does, man. So
Fair
anyway,
enough.
I thought they were two good ones.
Yes, no.
I made up for them.
Yeah, good call. Right, Roger.
Oh, look. I have one major pet peeve, which happens almost on a daily basis. It is tracked changes on Microsoft Word.
Oh.
If you send me a document and track changes, I will get on the phone and I won't be happy.
Yeah.
very unhappy.
It's like
Yes.
hazards of the job, right?
Yeah.
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 I
Just
can't stand it. I hate it
Yeah.
with a passion.
Jared would know all about it.
Mhm.
Yeah. Jared works on computers all day. Yeah.
I don't even know what you're talking about, to be honest.
Well,
what
I
is
mean,
it?
I don't know either, but I can understand how something like that could be really.
Oh,
Oh, don't get
frustrating.
me wrong. I can feel the hate. I can feel the anger.
I mean,
I get it.
You'd work on computers more than me.
Well,
I do
it's
now,
not so
but-
much hate and anger. It's more like a reign of terror and baptism by fire when you're actually having to go back and view documents that have been edited by track changes multiple times. And it's like,
Yeah.
Okay.
Give me the original.
yes, yes.
Yeah.
That's all I want.
Please underline it.
Yeah.
Underline it. Delete it. If you want, just don't change it.
Get your act together, people.
Absolutely.
Get your act together, because time's money.
Well, that's
Fine.
my pet peeve.
Yeah.
Nah, that's a
Yeah,
good one,
hey,
man.
hey,
That's a good one.
That's a good one.
Good contribution
Yep.
there. And mine would be I was at my daughter's mid-year dance concert tonight.
Mhm.
And obviously all the little kids, they get up on the stage and they do their dances that they've been rehearsing and practicing for this term and whatnot. And it always seems to happen like once somebody's kid has done their dance,
Oh, yeah.
they just feel like this is maybe somebody sitting behind you or in front of you. Just feels like, okay, well, once their kid's done their dance, they can just sit there and talk. And it's like there's other people trying to watch the show, and they've got somebody just sitting there talking, like behind you. It just kind of gets under my like, that little bee under the bonnet.
Are
a little bit.
they talking like at a like a really disrespectful level?
Yeah,
Decibel
like
level?
we are right now. Like, it's just,
Oh.
just sitting there talking, have a chat.
Yeah,
like
just go. Yeah, do that. That's fine, but don't be gas
yeah,
bagging.
that's right.
You
Oh,
know, show where's the respect?
That's right. It's just respect for the little kids that are up there doing their thing, like, and then respect for the other parents that are sitting there
Trying to enjoy their kids.
trying to enjoy the show, like, I mean, yes, I get it. These things can be a little bit painful sometimes. I get it, but it's only an hour and a half of your day.
Yeah.
Like, like let's just give the kids their space to do their thing.
At the end of the day, they all practiced very hard.
That's
And don't
right.
get me wrong. Like I couldn't sit there for an hour and a half. I'd probably be hey, to my missus, hey, or check something on my phone on dull, because we know how you feel about that.
Yeah. Wow. Yes. Yes.
Was there people with the cameras in front of your face?
No, I mean, they do mention at the start of these things, if you're going to film your kids, try and focus in on your child and not all of the other children and stuff like that. And I get it. It's something like that. You're proud parents. Get your phone out.
Yeah.
Film for a little bit. Whatever. Those sorts of those sorts of things are okay.
Yeah.
But like last week at a hardcore gig, having somebody's phone in my fucking face.
Yeah, and you just slapped it out.
Goose
All right,
I'm
relax, just relax.
I'm over that now.
That's
I'm
all
over
right.
it now.
You're good,
All right.
you're good, you're good.
You brought up an old wound.
I did.
Yeah,
I did.
so,
A sore spot.
Yeah.
I hear. And actually, you know what else ripped smart undies? These chairs.
Oh well,
If there's anyone out there that knows someone in the chair game,
it's all right. I'm always on the hunt, man. I'm
What's
always
wrong
on
with
the hunt.
them? They're absolutely
I've
quite
got a piece of
comfortable.
timber up my ass right now.
Well,
man.
you'd be the first guest.
Yep.
Roger.
You'd be the first guest that's enjoying it, because my sciatic is going to go.
These
The guests seem to love the chat.
these have been
Oh, wow.
Steve loved them, Jess loved them, Sam loved them.
I did not have an issue with them.
they've been a contentious subject.
must
for
have the good
52
one.
episodes.
Yeah.
Yeah. Braden's actually got the shittest one.
Yeah, I reckon absolutely I do.
So, yeah.
I might need to get a cushion.
Yeah. You can get a
It's
cushion if
actually
you
not a bad
want,
idea,
man.
actually.
All right. It's all right.
I don't like cushions. That'll rip my undies.
All right. Okay.
All right, let's get into it. Let's
Let's
get
get into
cracking.
it.
You said you were going to...
Well, Roger's gonna talk about what he does.
Yep.
And then once we've been through all that, then we'll sort of crack into some questions.
Rapid fire.
Yeah, we'll crack into some rapid fire questions for Roger. Yeah, we've got some questions coming through from Dad's community,
The herd.
some friends, and yeah. So yeah,
Well, I suppose what I'll do is I will start off.
yeah,
There is something that I would like to say
Yeah.
first off, and I think it comes into the broader context of the questions that's going to follow throughout this entire evening.
sure.
And I suppose in many ways it comes down to this: what is the family law system? Is it fair? And how can you navigate through it? But before we get to that point, I do need to give some general, I suppose you would call them tips, especially for men. Now, the one thing I've noticed throughout my career, and my career, by the way, started off with the men's legal service. I was a graduate when I started there, and very much thrown to the deep end, representing men who were, at the best of times, very hard done by, and that was clear. I learned very hard and very fast, and throughout that, I managed to gain what you will call a sink or swim attitude. Luckily, I was one of the people that was able to swim. And over the years, I've refined and developed the way I deal with people. And I'm very thankful for my early education and having to throw myself out there and learn very, very quickly. And I suppose at the moment, I'm probably at a level now where people see themselves at levels of 15 to 20 years post-admission experience. So I am thankful for the way that I've managed to get through the early stages of my career. The observations that I've had is that there is no real disadvantage in the actual system, but I have seen that men are completely underprepared. One of the tips that I have to give, I give to every single client that I come across. And I'll take a step back and I'll give you a general scenario. All right, you've got a party that's separated. Doesn't matter if they're married or de facto. Usually a child involved. All right, and it could go both ways. It could go male or female, but generally one party will go protection order, DVO.
Oh.
All right, may or may not be evidence. Who knows? Generally, it's the female that makes the application, but around about 25% of the times, it's the male that makes the application. Now,
That's
general
higher than I thought,
scenario.
to be honest.
Well, that's my observation.
Yeah,
more
yeah, yeah.
females than males will make the application. There's a reason for that, which I'll go into later.
Okay.
But you've got the application, and then police go and serve the application. The first mistake that men make is talking to the police. Now, there is a very famous quote in an American court. I can't remember off by heart, but most lawyers know it. And this judge said, no lawyer worth their grain of salt will advise their client to talk to the police under any circumstances. Okay? In the Police Powers and Responsibilities Act, you're not obligated to do anything with the police except to identify yourself with your name, address, and phone number, or some other identifying particulars. The problem is that the police officers will often come and serve this application and say, give us your side of the story. Tell us what's going on. And then bang, evidence is going to be used against you. And that's a very common mistake that men make. I tell my clients, don't talk to the police. Say what you have to say, take any documentation, and leave it at that. Now, by the time the clients come to me, they've already been served with the application. So chances are they've already said something. So that makes it harder for me. Then we get to the second stage, which is generally, in a fair few cases, more than I care to admit, followed by what we call a DV breach. Now, as you know, a protection order is a civil piece of paper that says, follow these orders and there won't be any problems. It's essentially what it means. The problem if you breach that order, even a temporary protection order, well then it's a criminal offence. Now, typical example, I got a call from a friend of mine a couple of years ago who was a female, and she's called me up when I was at work and she said, Roger, I've got a problem. The police called me up and they want to talk to me about a text message I sent to my husband. Husband had a ex-husband had a protection order on against her. Anyway, long story short, I said to her, well, no, you're not going to do that. You're going to turn around. You're going to go home. You have no obligation to talk to them. The police have to show a couple of things in order to claim a breach. So they've got to show that there was an order in place, that the order specifies certain things not to contact, and that you did contact. Now, the first two are easy to prove, but they've got to show it came from their phone. So what the police will often do, they'll come to your home and they'll say, mate, we've got this complaint against you. There's a protection order in place. Realise it's probably nothing much, but hey, just want to talk to you about it. The only thing that person has to say is, yeah, I sent it, but they've got them. They can convict. Never a good idea to talk to the police under any circumstances. It never helps your case. They're not your friend. They are there to do a job, and you are well better off talking to a lawyer. Now, I'll often say to my clients, if the police come around to your doorstep at 5 o'clock in the morning, 7 o'clock at night, when they generally do, because they know that those clients can't get access to the lawyers, give me a call and I'll have a chat to the police while you're there. And sure enough, that's exactly what happens. So men are very undereducated in the system. Women, unfortunately, do happen to band together, as they generally tend to do, and know things and are able to pass information through their social networks. Men, for some reason, just don't do that, and they have no knowledge of the law until the law bites them in the ass. Now, that scenario I gave you, first you've got a protection order, then you've got a breach. If there's a child involved, what's going to happen is she's going to file in the Federal Circuit Court. Now, the Federal Circuit Court is a completely different system. It is a Commonwealth system under the Family Law Act, 1975. And in that act, judges have to take certain things into consideration. So an application is made, and then there is an application, and that application will surely say, yep, there's an order in place, and he's breached the order, supervised time. No matter what the circumstances are, it looks bad on paper. So it makes my job harder to act for the guy. When it gets to that point, and this is the part that really, really doesn't agree with the way that men perceive the system. In the domestic violence court, we have a particular piece of legislation. It's called Section 145, Rules of Evidence Don't Apply, which basically means to make an application for protection order, you only have to have an allegation. Okay? You don't even have to show anything. You need to show that there's a relevant relationship and that there's an alleged act of domestic violence for a temporary protection order. To make a final protection order, you've got to show the court that the order is necessary or desirable. Now, it's extraordinarily easy to get a temporary protection order. So what generally happens is we find that there's a protection order followed by maybe sometimes a breach straight into the Federal Circuit Court, and it's used as a means of leverage against children. And that's both men and female, by the way. And certainly I've had male clients that have come to me and say, yep, I've got this problem. Yeah. Now, getting back to that subject, inside the Federal Circuit Court, those same principles are now starting to apply, because in the Domestic Violence Court, which is the Domestic and Family Violence Protection Act of 2020 of 12, that's Section 145, rules of evidence don't apply, which basically means there's no finding of fact at any stage until you get to a final trial. And that could be a year away. So you can say whatever you want in an affidavit, and they have to act on it at first instance. It's only at a final trial, when it's put to that person under cross-examination, then it can be tendered as evidence and used. So if I've got a male client that's come to me and says, yeah, I've got a protection order on against me and I've breached it, and now I've got documents to be served in the Federal Circuit Court, I tend to roll my eyes and go, oh, another hard one. It's actually not that hard though. It's just time consuming, all right? Because it makes my job a little bit more difficult. But the bad news, and I'll give you a very typical example of what I say to every single client. I will say to my client, look, there is no finding of fact at any stage of any proceeding in the Federal Circuit Court until you get to a final trial. And that's now true, because the rules of evidence that are prevalent in the DV have somehow, for some reason, filtered over into the family court. Now, I'm probably one of the few lawyers that have actually picked up on the fact that it could be construed as a fundamental, you would consider, erosion of the rule of law, innocent until proven guilty. Okay? That could be construed as a possibility. I mean, if you're...
Why is it that now we've
Well, look,
seen so many cases that it's like you're guilty until proven innocent?
almost-
Let me finish what I have to say, and I'll get to that point. Now, in the Federal Circuit Court, the general pathway is you make an application. If it's an urgent one, you get heard pretty quickly. If it's not, you get a first return date about a month and a half later. At that return date, the other side will be expected to have filed a reply or a response, and then you've got affidavits from two people and an application that sets out certain orders for interim and final, and an application that sets out certain orders for, or certain responses for their interim and final. And then generally what happens then is you go to a child impact report, and the children have to be interviewed, and then an interim hearing after that. That could be around about anywhere between 1 to 4 months, maybe longer, maybe 6 months, depending on the availability of the courts. Now, the one thing that my clients seem to have difficulty, both men and women, is the fact that I say to them, look, you're going to go through a hell of a lot of crap in the next couple of months, because what's going to happen is what you've put before the court and what the court has been put before with what your other partner has said, there's no finding of fact in it. So even at an interim stage, a senior judicial registrar or a judge can't make a finding of fact on it. They can't, because that's the way the system's been set up at this point in time. I would like to see that changed, but it's only in the final trial when affidavits can be put to each other and under cross-examination and a determination made. Now, it's not uncommon. Most matters actually never go to trial. 99.999% will actually not go to trial, and most of them will stop on the day of trial or the week beforehand. And there's a very good reason for that, and I'll give you that reason. If I've come into a matter and I'll give you an example of one I did a few months ago when I took on a matter at the last minute, and I said to my client, look, you're a lovely guy, but you've thrown so much garbage at her throughout these proceedings that your affidavit and your affidavits are completely contradictory. You're going to get up on stand and you're going to be cross-examined. They're going to be picked apart by a senior barrister. You're going to be sweating and shaking for a day and a half. I can't put you on the stand because I think that you're at a risk of two things happening. One, you get bad credibility, or B, the worst case, although rare, the instance of being able to perjure yourself, which can sometimes happen. So if somebody points out a contradiction, it's not uncommon for me to say, well, I will give you an example. If somebody has come to me and I've taken on a matter, and then we go all the way to final trial, and then the mother's up on stand, and I'll say the mother this time because it generally does tend to be the females in my experience, and I would put that about 75% of the time. I'll say to her, you're a liar, aren't you? And she'll say, no. I say, okay, I'll get you to read out this paragraph, please. Yep. Now read out this paragraph. And then I say, they're not the same, are they? No. They're inconsistent with each other, wouldn't you say that? No. Okay, so which part is not inconsistent? And then it would be a case of I'm having to identify and isolate which part is wrong, so I can say the golden words, that's an incorrect statement that you made on that affidavit, isn't it? And you're a liar. And then it would be a case that in my submissions, I would put in my oral and written submissions, no weight should be put on her evidence because she can't be trusted to tell the truth. That's what happens at a final trial. So that's why most matters never go to a final trial, because of the risks that are happening. They usually resolve on the day of or the week of, when barristers and solicitors tend to get on board and go, yeah.
There's too much GST added.
Yeah, yeah. And look, in all of my experience, I've often heard the comment after the trial, and I'll say a female that I just spent something like 3 hours grilling her ex-partner on the stand. She said to me a day later, that was the most satisfying thing I've ever seen in 3 years that I've gone through this. I said, well, some people get some therapeutic justice out of watching the other side get grilled. And if you have ever been the subject of having been cross-examined, it's never a pleasant experience. No. And sometimes you've got senior counsel on there that have been doing it for 25 years, and they know how to push your
Just
buttons.
baiting you, not baiting you, but they're like
Yeah.
they're setting.
Yeah.
It's like a
not setting
professional.
up.
It's like it's
Yeah.
like playing a professional chess player when you're an amateur.
Well, I've often said, and this is the part that I want to get at. The best thing anybody could ever do is get legal advice very early. Okay, it's very important that you do not say anything to anyone until you see a lawyer.
Do you find that a lot of the guys that you deal with, they haven't got any legal advice or done any legal research because they get blindsided by the whole situation?
The legal advice that they're getting is completely wrong in
Yeah.
half the circumstances. When they come to me, they're actually quite baffled by what I'm saying, well, why is it like that?
Well, I'll reiterate that actually. It's not being blindsided. It's being blind to
Yeah.
the situation, because a lot of the time there's a lot of things that go on in a build up and a lead up, but the men are oblivious to it happening
Yeah.
until it happens.
Yeah, the men are like, oh, it just came out of nowhere. But the
Yeah,
other side's
but-
like, oh, mate, the writing was on the wall.
That's right. It's been a year in the making. You know, like yeah.
Well, there's two parts to that question. One is the fact that men tend to, they don't tend to worry about the legal aspects. I mean, we are in Australian culture, first and foremost. Men love to go out and have a beer and go footy. And typical example is when you go into a police interview for recruitment for the police service, they'll say to you, look, you've got an elderly woman at the back and you've got a couple of rowdy guys, you know, yelling and screaming at the front. What do you do? And the correct answer is, well, everybody's out just to watch the game and have a good time. They're not doing anything wrong. But some people look at a male and you could probably call it the bad boy image. But they look at the male and they think, yep, all hunky-dory. But men can be often very intimidating in the way that they talk to female, and it comes across that way. Yeah. And one of the things that I've done when I've represented females is I've made a habit of getting my female client to sit as close as possible as she can to the other respondent. And the reason being, you've seen this tall, short, timid girl, and then there's a big bad guy with tats and everything hanging out. And the court's going to get an impression of that. And I've often said, you only have one chance to make a first impression. So you don't get a second chance. Luckily, very luckily, when you go to the Federal Circuit Court, usually the person who's running the trial is a different judge than what you've had. So I'm not too concerned. But interim hearings, they're looking at this person. He may be a lovely guy, but completely covered in tats, and he's giving off an impression of, yep, I'm big bad guy, and this young sobbing female crying victim on the side here is weighing up in the judge's mind. It's almost like an autonomous thing. And look, judges are supposed to be designed to be fair. And I have no doubt that each judge looks at the merits of the case, but you can't get past the fact that you've got a comparison right in front of you. And sometimes that can be triggered or can affect your evidence that you're giving. So you've got to be very careful about the way you present yourself in court. Yeah. Sometimes I'll tell my clients, don't turn up if it can be avoided, especially at DV trials. Sorry, not trials, mentions. Mentions, I'll often say, you don't have to be there. In fact, I prefer you not to be there. Purely because I don't want to give any false impressions. I'm there for a purpose.
Don't want to sway the case.
Yeah. And I'm meticulous when I say to my clients, when you come to court, please, for the love of God, wear something good, smart casual, navy blue or neutral colours. Make sure you're nice, cleanly shaven, any tats are hidden, as presentable as possible, and leave it at that.
I'll be going to trial in a bloody
Yeah.
a long jacket and gloves.
But with that disclaimer comes that part of the reason that people pay me is not so much for, well, it is, but one of the main reasons that people should be paying me for is because I know almost every single Federal Circuit Court judge in the system, and they're all different, and they all have their tendencies. And at the end of the day, they make discretionary decisions according to the evidence in front of them. So you've got to know the judge, or the senior judicial registrar, or the judicial registrar. And it certainly helps when you've been around the traps. I know one Federal Circuit Court judge who can be very legal formalist and wants everything done strictly by the book. I know another one who's very relaxed with the rules, and knowing that gives you a certain, I wouldn't say an advantage, but a certain
Edge.
edge.
100%. Well, it's like any sport.
Yeah.
You're like the coach. You got to know how to play against your opposition.
Yeah. The one thing that I see that self-represented litigants do very wrong is they try to be smart. Okay, you're not there for that. You're there purely because you're trying to get an outcome, and you're asking the court essentially, what do I have to do in order to get more time? And that leads to my next discussion, okay? And this is very, very important, what I'm about to tell you. And it's something that you won't ordinarily hear,
Oh,
except for my clients, who I tell almost on every single time I see them. It's not about you. It's not about her. It's about the children.
That's right.
Okay? So you can pretty much do anything you want or get anything you want if there's evidence to support it. Okay? So if you want to have more time with the child, I mean, you have to do certain things. And that benchmark is actually surprisingly not high. The one thing I like to do whenever I'm starting off an application, and I do like my clients to come to me before we go to court, if I'm starting off an application and I know that the other side is going to raise an instance of alcohol, I say to my client, look, if you're saying that she thinks you're a drug user, then we should go and get you and get a hair follicle test to put at the back of your affidavit. That will negate any argument that she throws at you. Okay? If there's allegations of alcohol, same thing, CDT test, put at the back of the affidavit. Parenting order calls, go out and do that before you file your affidavit and your application. That way you can show the court that you're doing everything you can possible in order. Set up a parenting app. Send a few nice messages to the other side to show that you can co-parent. Because what will happen, if you consistently do that throughout the proceedings, then the court's simply going to say, nothing wrong with him, must be her. And I got to say, in all of the cases that I've had with men, there's the only really thing that works for reversal of care is an argument that there's only one person in the room that can actually do what is expected of the court. And the modus operandi of my submissions is always the same. And it's, Your Honour, you've heard the evidence. You've seen the evidence. You've seen my client from the word go, Your Honour. He's done everything he can possible in order to maintain and facilitate a relationship. He's been systematically shot down every single time. Nothing's worked, Your Honour. He still hasn't had time with his child. His child is now 7 years old. We started these proceedings when the child was 5. We're in a situation where he spent very limited time. There's no risk, Your Honour. Anything that has been raised has been shot down. He's produced hair and follicle tests. He's got no record. There's no child welfare records. There are 2 people in this room, Your Honour. One of them has shown that they are willing and able to facilitate time between the child and the other parent, and you've got another person that has done everything they can possible in order to hinder that. As far as I'm concerned, Your Honour, you have a very easy decision to make. And then the judge will deliberate for about a month and comes back with a, I'm not satisfied that the mother is going to comply with the orders, and therefore I see no other option but to order reversal of care. Now, for that to happen, obviously, several things have to happen. The father has to be able to show that he's able to facilitate that relationship, that he lives fairly close, that he's able to take the child to school. And these things, can be hard to do if you're working full time. And the court is satisfied that the child is going to be able to cope with it and cater with it. So maintaining and establishing a strong relationship with the child is essential. And a lot of my clients will say to me, Roger, do I have to go get supervised contact time? Mate, I hear you. Just do it. Because if you don't do it, if you're going to sit there stubborn and say, I'm not going to go to contact centre because I haven't done anything wrong, then what's going to happen is she's going to say, he hasn't seen the child in over a year, and the child needs reunification therapy. Just do it. Do what you have to do. And that's why it's very difficult for men to hear. But if you ask me if the system is unfair or biased, no,
Oh, check that off the
I
list.
don't believe that at all. Because the court has to look at all the evidence that's got in front of it. Sometimes men can be really stubborn, but that doesn't mean that they're disadvantaged. They simply have to get past their own limitations, swallow their pride, and just do it. If they can stick it out to a final trial, and look, trust me, it's not that easy. Sometimes they give up. Sometimes they just say, this is not working, Roger, I can't do this anymore, I'm so stressed. Give her whatever she wants. And it's pretty heartbreaking. In my early stages of my career, I had this, a very nice guy who was a reformed alcoholic, and his ex-girlfriend was not the most savoury person. What had happened was she took a video of herself punching him, and the police took action, put out a protective order against her. First thing she did was take the kids off him, because they had a shared 50-50 at the time. Anyway, got before the court. She produced a text message from years before where he threatened to kill himself, and the judge goes, yeah, no, here's a risk, supervised time, and we can't come back here until, say, November. And it was March. And he went home and killed himself that night.
Oh,
So that was one that stuck in my mind. And look, that judge is no longer on the bench. He's since retired. But I suppose at the end of the day, that was my first introduction to, I wouldn't say the hard aspect of family law, but it's the one that made me realise that men really do need to have pre-education, honestly, because with that particular client, if he had known the system, and if he was able to show that, well, it's probably better in the long run because he would have got a reversal of care. If he'd kept it up, and all he really had to do, he'd been reformed alcoholic and he had the certificates and all of the AA meetings to prove it. We stuck it out for another half a year, but it was just too much. Yeah. And he loved his kids. But I will say that the hardest part for me personally as a professional, and it almost actually ended my career, I got an email from the solicitor on the other side about a few days later, and she goes, well, I guess your client was really all he made himself out to be. And I was just absolutely gobsmacked. And I do recall his mother had called me up and blamed me because I did all off the day before. It was, But look, given that there's been completely different circumstances where I've had female clients that have attempted suicide because they haven't been able to get an outcome. I myself have taken on 1 or 2 pro bono female clients because, quite simply, there's been no other option for them. Legal aid have turned them down. I used to do a lot of pro bono clients for males in my early days before I started my own law firm, and volunteered at the Pine Rivers Community Legal Service. And I still do to this day. But I suppose in many respects, my early education has led me to where I am now. And I'm one of the few lawyers I would tend to think that, wouldn't say aggressive, but not going to sit there and say, and take a simple, well, no. It's not going to happen because I'm just going to tell my client, sit there and deal with it, and we're going to get it down the track. Yeah. Because all you've got to do is few steps, and it is, in many respects, a chess game. Tic-tac-toe. And if you know the system and you know how it works, you've got a bit of an advantage. And you have to keep in mind, at the end of the day, this is an evidentiary-based jurisdiction. So the court will always deal with the evidence before it. If you've got the evidence, there won't be anything.
Why does it seem, though, I guess from an outsider's perspective, that even with very little evidence, men can still be, like, thrown into the fire? And I guess, like, through the statistics of history, men are generally always the perpetrator of, domestic family violence or aggression towards, gender-based violence and stuff like that. So because of that, is that why? Like, is that why that men have to prove their innocence? It's not
Well,
like,
look, this is the part where I have to thank men for doing what they do. Because at the end of the day, I said to you before, there's no finding of fact. You can put whatever you want in an affidavit. And quite frankly, I've seen some real great big fat porcupine lies in affidavits. Men don't tend to retaliate.
no.
The affidavits in response are generally quite okay. They will say inflammatory things, yes, but generally I find that it's a lot less than what you would find a female applicant would put down. And I got to say, part of the correspondences I send out to some solicitors will often include a ruling. The case is called Walcott, and if I find a contradiction in an affidavit, I'll politely send a correspondence to the other side, pointing out you should consider what His Honour said in the case of Walcott. Solicitors and barristers have an obligation to fact check and reality check their clients before they put it in an affidavit. And that just puts the solicitor on notice, because I'm not sure if you're aware, but since the Federal Circuit and Family Court of Australia, Family Law Rules 2021, there's a particular piece of legislation, it's 12.151C. It basically allows the court to award costs against the lawyers personally against a number of things. So sometimes lawyers can be sued personally. And one of my pet peeves is seeing things in affidavits that clearly shouldn't be there, and they should be struck out. So sometimes I will often send correspondence saying, look, you really should have checked that. It shouldn't be an affidavit. Can you please withdraw it? Otherwise, if you don't, I'll put you on notice that blah, blah, blah. And look, I don't like to be that kind of person, but my client is paying me to make sure that they are going to be treated fairly. And if I see evidence before the court, well then, under the Australian Solicitors Conduct Rules, we have an obligation to make sure that the court isn't being misled. So that generally where it comes down to. Look, I congratulate men for not retaliating in the way that they do, because they're generally responding to applications, not initiating them. Yeah. And they're not, in such a respect, being thrown into the fire, because you have to understand that if they just let it slide, it will eventually come out. And I will often say to my client, let them do it. Just let them do it. Don't let it bother you. If I could, I would not send my clients any of the affidavits and not let them read it. But I have to. I've got a legal obligation to. But if they didn't know about it, because they read this affidavit and they get so riled, and they think that is just one big pile of baloney, Roger. And I'm like, okay, don't worry about it. I mean, it's up to her to prove it at a final trial. Now, at a final trial, in both the DV and the Federal Circuit Court, we have something called the Brigginshaw standard. So let's just say that somebody in their initiating application makes an allegation that, you sexually harassed, or a man sexually harassed a child. So first thing the court will do will order the 67 ZBD material from child welfare or the police. And if there's nothing there, well, their credibility goes down a bit further. If they produce some evidence, a photo or video or whatever, the court's going to say, why didn't you report it to the police? If they've got a reasonable answer, then, yeah. They've got to show their case at a final trial on the Brigginshaw standard. Now, quite often, the mistake that's being made is that in their notice of risk, they'll put down, has the child been sexually abused? No. But then in their affidavit, will be something completely different, or other way around. They'll tick the box called sexual abuse, and then they'll fail to put in their affidavit. Yeah, being completely unprepared correctly. But these are the kinds of things that the courts look at. So when you go to the final trial, all of this is pulled out and saying, well, why was it not reported? If it was such a concern, why did you allow him to have supervised time with the children? He can't be at risk, can he? Oh, no, I was a bit worried, but I wasn't sure. Well, no. Madam, you are the mother of your child. If you thought that he was a risk, why did you allow him to have unsupervised time? Oh, I felt like I had to. Madam, I want an answer, please. Yeah. And this is the kind of thing that you can expect at a final trial. I mean, it's not pleasant. Trust me. It really isn't pleasant. So I don't think for a second that the system is unfair. I think that the only problem for men is the fact that they have to sit there and bear the brunt of it. But like I got to say, if they've done nothing wrong, then they've got nothing to hide, and they just go through the system. And I've had the pleasure of supporting men and representing men who have done just that. I said, okay, Roger, not a problem. I'll just ignore it. Sure enough. And then every week they go to their supervised visits, and it's going really well. And we get the report from the contact center, and then the family law report writer says, "Yep, no problem there." And then reversal of care. So it happens more than you think. To be fair, and that's my other point. If men took the time to read some of these judgments, in the past 3 months, I've counted at least 10 or 15 reversal of cares to men, at least. They're the ones I know about. And I set my Jade up to alert me every time that there's a reversal of care and an urgent watch list order. Some of the things I specialise in are urgent applications, and what we call recovery orders. I've done 4 of them in the last month and a half. Generally, it's when the man has taken the child and somewhere where nobody knows, and we've had to get the judge to order a recovery order. One time it was a male that had the child recovered to him.
Yeah, because you can't just pack up and take your kids, can you?
Well, I do remember a case on Christmas Eve a few years ago where somebody rang me up, goes, "Oh, she was on the tarmac and texted me that she was going to another state. Want my kids back." I'm like, "Oh, great." So Christmas morning, I filed an urgent application, which was heard I think it was mid-January. Yeah, it happens.
Yeah.
A fair bit.
I've got a question. I have been sitting on it for a long time, and it's
Your ADHD brain.
ADHD brain has gone nuts. And it's a simple question.
Yeah.
Shoot.
Why do we make it so, or why is it made so easy at the beginning just to say, hey, this is the accusation, and then all of a sudden, why isn't there enough evidence being put forward at the beginning to back that?
Yeah. Like I said, this is where it comes down to discretionary decisions at the interim hearing. No finding of fact, so they can't make a finding on it. So the onus is on you to show that you're not a risk. So if they make allegations saying you're a drug user and blah, 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 and you haven't got a hair and follicle, the court's going to have to err on the side of caution. That's what it is primarily designed to do, to take into the best consideration of the child at the time. If you've got that, then you can say, "No, nothing to see here." And they could go, "Okay, fair enough, not a risk." But it's difficult because you can't test the evidence until you put that evidence before that person and have it under cross-examination, and it's considered intended as evidence. That's the reality. So findings of fact can't be made at interim stages. Like I said, I would love to see that, and I don't know why that has been the case. I haven't got an answer from anybody, and I've asked senior counsels. I haven't asked a judge off the record, but I would love to know the answer to that question too. And it would make it easier if there were findings of fact that could be made in interim stages, because then you at least could be able to say, well, definitively, not enough evidence from the go-by to pursue that. They've got to drop it. But one of the things that will irritate a lot of solicitors is that very sentence. "I'm not making that finding of fact today, Mr. Poed. I can't make findings of fact in interim hearings. You know that, Mr. Poed." Your Honour, he's produced a clean hair and follicle. He's had unsupervised time with the child before these allegations occurred. Again, Mr. Poed, you've produced a psychiatric report, but it's not tested, Mr. Poed. Yeah, I was in a situation where one of my clients had a history of mental illness, and the child was being withheld on the basis that he wasn't safe. But he got a report from his treating psychiatrist, and no finding of fact. So the judge is saying, "Look, I'm not going to interfere with the status quo at this point. It's a finding for final trial, Mr. Poed." So then my client had to get a family law report, and then year and a half later, we're still wanting to go to trial.
Yeah.
Is it?
How come the system can get so dragged out
Yeah.
for some dads and not others, though?
It comes
Like-
down to personal circumstances. Like
Yeah.
I say, if clients that come to me at the very beginning, at the very onset, and look, I don't know if any of my colleagues are going to hate me for saying this, and certainly I don't mean to disrespect any other law firm, but the complaint that my clients will often make is they say, Roger, I'm coming to you because I can't afford a top-tiered law firm anymore. Now, they see this year-boot law firm, top-tiered, and they go for a consultation and they're sold, and then $20,000 down, and they haven't even filed in court yet in some cases. So I was part of the winter call-over in August 2021, I do believe it was, where the new system was coming in and judges were called on for the winter call-over to triage all of the systems that have been, all of the cases that have been ongoing for 3 years to try and resolve them. And I do recall one judge completely berating two solicitors in front of me for the amount that cost their clients without going to trial. I won't say what the amount is or who they were, but they were on the call in front of me because it was by teleconference at that time. And she demanded to see them in her chambers personally that afternoon to explain why they shouldn't be referred to the LSC.
Mm.
And you often see some cost notices that have come out, and some of them are just so gobsmackingly huge. You go, whoa! We're talking about 100.
So I mean, like, how is that
150,000.
affordable for the normal person? Like, say
Yeah.
if
Of
I
course
got
they
into
stop.
if I got into that situation, I'd be fucked because I couldn't pay it. I couldn't pay it.
And
Like,
a lot of people can't.
Yeah.
And we find a lot of people say, Roger, I can't afford the top tier. I've already spent 20,000. What can you do for me?
Yeah.
So now the beautiful part as a legal consumer, you've got a couple of rights and we've got a couple of obligations. One of them is the fact that we have to give a cost note or a cost update every time something happens. So if you come to me and say, Roger, you need to file an urgent application, I say, great, no problem. Costs you $3,500 for the paperwork and the first appearance. Yeah, okay, I'll cap it at that. Not a problem. Okay, so that happened with my female client not so long ago and got the recovery slightly over, but 4.5, not a big deal. Got the child back. And then the other side decided to go, yeah, no, stuff this. We want to open up the proceedings again. So I said to my client, well, if you want us to represent you for that, then it's going to cost another $5,000 and we can do this and that and that and that. So what generally discourages men is when they're not told, in particular, what they're going to have to pay up front. Now, if you go by stages, you're great. You can put that money aside and say, okay, I can rely upon that. He said it's going to be up to $5,000. Yep, not a problem. Worst case scenario, if it's urgent, simply say, well, okay, this stage is going to be essential. You can't afford it. Put $2,000 into our trust account. You can pay off the other by installments or whatever. Top-tiered law firms tend not to do that because most people go to top-tiered law firms because of the billboards. Very few people go to the boutique firms in the suburbs. These top-tiered firms are spending hundreds of thousands of dollars in marketing for Google searches and Google ads, so they tend to pop up first, and the ones that people go to, good reputation, why not? But they look at the price and they have a nice interview, and these lawyers are very, very smart, generally. Know what they're doing. It doesn't mean that other people don't either. Now, we'll have to say in that respect, it doesn't really matter what barrister or solicitor you go with, because at the end of the day, and I quite often make this distinction, if you hire a senior counsel, maybe like James Linklater Steele, who's very, very, very hard to get, or say a junior barrister, both of them still have to look at the same piece of evidence, and they still have to reach the same conclusion, mildly. Yeah. So, look, when you're thinking in terms of that, and you're a male going through the system, it's very important to shop around at the onset and be very clear with the person as to what your costs will be. And particularly, if I can't afford you down the track, is there scope for you to do payment plans? Or is for scope for you to do something else, such as deferred payment, or if it's a property matter, deferred settlement. These are the kinds of questions that they should be asking your lawyer at the initial consult. Now, you should never really pay for an initial consult. That's my view, because you've got to feel comfortable with the lawyer. So you're going to want to go through a number of other lawyers before you make a decision about which one is the best fit.
Kind of like a free quote.
Yeah.
Yeah.
That's exactly it.
Yeah.
Yeah, so the advice I've given clients is if you're not happy with me, fine. I'm not going to charge you for a consult, but go and have a look around, see what's out there.
Yeah.
You've got to feel comfortable with your lawyer, and they might not like what I say to them. And I tell them straight, look, you're going to cop a lot of shit, mate. I'm not going to take those instructions to go out and get her.
Yeah.
I've got a job to do.
Yeah.
I'm going to get you where you need to go.
Yeah.
It is a pathway, and I can help you navigate it, but if you're not comfortable, then have a shop around. And if you really want me, come back and get me, and we'll get you on a client agreement. Now, it's very important for that to occur, but like I said, I think it's about time that men need to be starting to be aware of what their rights actually are. Look, if I had my way, every single male would have a copy of the PPRA in front of them. The Police Powers and Responsibilities Act in their glove box of their car. Honestly, even I've looked at that sometimes and thinking, oh my God, did that police officer just do that?
Yeah. So I talked to a gentleman just the other day, actually. I work in housing, and I went to this house to do a maintenance job, and I got talking to the guy there, and he had not long come out of jail. And I said, do you mind if I ask what you went into jail for? And he said, I was accused by my neighbour of DV against my partner, but there was no DV case. But there was an argument that happened between me and my partner, and the neighbour called it in. I had the police turn up on my door. I was arrested. I was put in jail for 2 months. The partner didn't want a DV put on him, but he still got arrested. So how does this happen?
Well, you've got two types of applications. One's what you call a police application, and one's a private application. Both are same in weight and value. Now, back in the older days, about 20 years ago, back in around about the year 2000, we didn't have a police power or Domestic and Family Violence Protection Act. It was based upon common law. Then this act came in. Now, the police used to come to a scene and a domestic scene and observe yelling, screaming, fighting and say, yep, okay, I can do that. So they put a protection order, a police protection order on that person, and they'd oust that person, or they'd do something else, or they'd make these orders. And anyway, this person would appear in court and they'd get a temporary protection order, blah, blah, blah. Now, nowadays, that's loosened up a little bit. Nowadays, you can walk into a police station, talk to a police officer and say, look, this has happened, and oh God, blah, 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 blah. And the police go, oh, that's really bad. Okay. So the police go out and put a police protection order on against that other person. But the problem with that is you go to a final trial, and I'm sure you can guess what would happen. Yeah. The police can't give evidence because they weren't there. They didn't see what happened.
Yeah.
So all they've got is hearsay evidence. So if in that situation, the other side turned around and said, no, don't want to give evidence, well, then the police case essentially falls apart. Yeah. Now, the police can still continue on with an application for protection order if that person doesn't give evidence, but their case becomes weak at a final trial.
Like, obviously, this guy had a history. Yeah, this guy.
Yeah.
He had a history. He, is an ex-gang member, and, he, like you're saying earlier about appearance, he didn't really look like the savoury type. He looked a bit unsavoury, but he was adamant in this situation. He didn't do anything wrong. He still got arrested for it and sort of put away for a couple of months. So
when you say he was arrested, I would have thought that he'd breached an order of some sort because...
I mean, obviously, I'm in a 5-minute conversation with this guy, and
if he spent 2 weeks in a watch house, then it'd be safe to assume he's breached a protection order, and for some reason he couldn't afford bail or whatever. I'm not sure. But generally, the police have the power to prosecute a domestic violence protection order if the aggrieved doesn't want it. Um,
Why?
well, it comes down to the three elements. The police may deem it to be necessary or desirable, even if the aggrieved doesn't want it. So I told you before that the Domestic and Family Violence Act, under Section 37, you've got three factors there. Section 1A is a relevant relationship. Tick that box. B, is there an act of domestic violence? Now, the police have to prove that case on the Brickenshaw standard more likely than not, even if the aggrieved doesn't give evidence. Sometimes they can. Sometimes it's very hard if the aggrieved doesn't want to give evidence. But the police may put a lot more weight on the third factor, necessary or desirable. They may convince the magistrate that, look, unless Your Honour makes this a final 5-year protection order, this guy could do it again. And the magistrate is going to want to err on the side of caution because no magistrate is going to want their name splashed across the front page of a news for making a protection order.
You let this person
And then
walk and
let this person walk, and then all of a sudden, this social uproar.
Yeah.
So the court's more than more likely to err on the side of caution.
Yeah, like I said to him too, I said, but in the same regard, isn't it good in a way that the system could be working? Because if you had have been abusing your partner and the neighbor has called and the police have come and arrested you, then at least that has worked the way it should work, right? And he said, yeah. I would hope that the system would work in the way that it needs to when it needs to. And I said, yeah. So I said, that in itself is good because it means that they're not taking any bullshit when it comes to the DV. Because, I mean, obviously we can be next door and hear something going on and we don't really know what's going on. Sounds like there's a big commotion. So what do? You call the police because you would hope that if you were in a situation where you actually were in a DV situation, that somebody might fucking step in and help, So I said to him, I don't think your neighbor was in the wrong by calling it in. I said, obviously she felt like she really needed to in the moment. And he said, yeah. He said, but I wasn't beating my wife. And I said, yeah. I said, that's, I said, but the police came and they did their job, right?
But there's smoke, there's fire.
Yeah.
That's what, like, I'm not saying that he did it either, but I'm just saying, like, you would,
No.
This is the whole thing about what I was getting at before about, like, there should just, I don't, like, and you said just, why is there no actual evidence before these things? Like, you should have to prove these things if you're making those kind of allegations.
Yeah, and generally you have to wait for final trial for that.
Yeah.
Now, like the police, whether it's right or wrong, I generally dislike it. Now, the police, well, any party can withdraw at any stage of the proceeding up until the minute of the final trial. So, if say I send a letter to the police saying, look, I believe your case is frivolous, and I believe that you're not going to get up on the Brickenshaw standard, and I think that we're going to be going to trial, putting on notice that I'm intending to seek costs. Generally, they'll ignore it because there's no real incentive for them to withdraw up until the minute of the final trial, because the court will only award costs at a DV trial under Section 157 of the Act if it's found at a final hearing to either be frivolous, vexatious, malicious, or deliberately false. Now, they're really high to cross. And look, I've been in this game for a fairly long time with DV, and there's only one or two times where I've actually managed to get costs against anybody. It's not easy. It's a very high threshold to make. So it doesn't matter how much I put people on notice. The police can, in theory, turn up on the day and say, yep, we're not proceeding. And then you've just gone and spent $10,000 on counsel to defend you for the day. Yeah, it is a little bit unfair.
Yeah.
Particularly since you know that the case is not all that's cracked up to be.
They've just taken it for kind of like a ride.
Yeah, and look, to be fair, a lot of my clients have become very financially vulnerable because of those allegations. Some of them have been in prestigious positions. One of them has been involved in the mines where he dealt with the explosives. and his license and his ability to work and earn some really good money was completely shattered because of the temporary protection order.
Yeah.
Another guy, had problems with his protection order traveling to America. He got rejected and turned around, and that happened a couple of years ago. So, look, there are some pretty serious ramifications for protection orders, even if they're made by consent. Unfortunately, it doesn't distinct whether it's consent without admission or whether it's a finding of fact to a lot of these jurisdictions.
Yeah. Yeah. I have a question about when two people separate, okay, and they go into a 50-50 situation with the children.
Mm.
And obviously, if there was both parents are working, why does the male still have to pay large amounts of child support in that situation? Like, is it, like, obviously this isn't something I know a lot about because it's not something I've ever had to go through. But is it a percentage based, like between the pay gap between the male and the female, or the male and female, or is it based on something else?
I think if you've ever read the Child Support Assessment Act,
I have not.
yeah,
Sorry.
every single person I've encountered do not know the answer to that question.
Yeah.
It appears to be now. Look, don't get me wrong. Women are very good at calculating how much they're entitled to get, but the reality is it comes down to how many nights the child spends with each person, how much the person makes. It comes into a whole wide range of things. If I had to calculate a child support assessment, it would take me, realistically, as a lawyer, about 3 or 4 hours. And there's an online calculator you can use on the website of the Child Support Act, but I don't really put much faith in that, to be honest. I don't think it's an accurate portrayal. And it seems to me that
a broad guideline, but
yeah,
you wouldn't
it's-
hold it to any
no.
water.
And look, you hear of people all the time asking for reassessments. The difficult part that my clients have is realizing that child support is not part of the family law system. It's completely independent.
Yeah.
The only way it intertwines is in instances where you can make an application for departure order inside the Federal Circuit and Family Court of Australia, even inside a family law proceeding. And that's in extenuating circumstances and only under conditions when you've applied to the other jurisdiction, which I do believe is the Children's Court, if I remember correctly. Don't quote me on that, but I think that for the most part, child support is always going to be the most hated jurisdiction. And it certainly does appear to be that they have unlimited powers. They have access to all of your records and all of your financials, even ones that even you probably don't know about. So I'm often amazed at what the information that is gleaned at this. And my clients have often said to me, can I please get an order inside there saying that it's not to be disclosed to any other person or for use in child support proceedings? And I have to tell my clients, look, I can't guarantee that. Yeah.
Do you think the big misconception is like they don't actually realize that the reason why they're paying more in child support is so that child has equal, I wouldn't say opportunity, but like the same life at both parents' houses. It's not just about funding the mum.
Yeah.
It's like, to me, that's, for some reason, that's what I used to think a lot about. But really, it's giving the same,
Guess
giving the opportunity for your child to have the same stuff here than what he would with you.
I guess part of that problem is though that
They have to spend it.
there's no receipts
Yeah.
that have to be proven.
Yo,
for
in
the spending of the money,
in
right?
theory, that's what it's about. But
Yeah.
it does
So-
get misused.
Yeah.
And it's funny because one of the things that has really sort of bothered me, and I finally asked a female about it the other day, because throughout the last couple of years, I've noticed in all of it was in my affidavit, my generic affidavit that I draft up, there's always a section at the end of it called My Current Circumstances, and it usually goes something like this. I live in a 2, 3, 4 bedroom home. I do this for my employment, I earn this much, I pay X amount in child support. And I've noticed that men aren't paying child support. And I've asked the female, well, why is that? And she goes, I don't know, I just don't want anything from him. And I said, well, you're entitled to it, so why not? She goes, oh, I don't know, I don't want him to have, I don't want him to have access to my child, so I don't want him to pay for anything.
Yeah.
I'm like, okay. It's a rather odd answer, and it's always stuck with me actually. And it's interesting that you raised that question. To be fair, I think it's a good and valid point as to why people pay or ask for child support. And look, I've got no doubt that there's some people out there that use it for leverage. And the more nights you have with a child, the less the child support goes down. That's simple fact.
Like I understand the fact that, right, like say, you have a male and a female, they have 2 kids, okay? The man's been the provider for, say, the first 10 to 12 years of the children's lives because the mum's been a stay-at-home mum or she's been casually working or whatever. So generally she hasn't been putting any money into a super, she hasn't been putting any money into her back pocket. There's he's been bringing in all the money. So if they split and she leaves, she's in a position where she's not very financially stable, right?
Yeah.
Because she's still having to look after the kids and manage the kids when she has them. This now puts him in a position where if they go into a 50-50 situation, he has to then obviously probably take some kind of pay cut also in order to make that happen. So generally a lot of the time he won't. Yeah. He gets a 1 weekend every 2 weeks or something. She keeps the kids for majority of the time. He pays X amount of child support. That's obviously to help the children. She's obviously just getting some kind of support payments to help out, but she doesn't get back on her feet because it's easier for her to receive these payments in some
quite
kind
often
of way.
I raise that as an example of property settlement. And look, obviously the first stage of any parenting proceeding.
And sorry, but I mean that can go both ways too.
Yeah.
Like, this
Yeah,
is
of
not
course.
just a man doing this to a female. This can
right.
happen from a female to man, but predominantly it happens from
Yeah.
man to female, right?
So generally you have to attempt mediation first before you can file any application, whether it's parenting or property.
Yep.
Usually they're entwined, especially with most of my cases anyway. So it often amazes me. You get to a mediation and you have a situation where you've got your disclosure documents and then you've got parenting and property to deal with. Now, one of the factors, you're right, that come into it is, well, how much time is each party going to spend with the child? Because that affects the property split. So what really irritates me is when the other side will say to me, we want to deal with property first. And I'm like, oh, God, no, that's not going to happen. Because you need to know what's happening with parenting first and how many nights the child is going to spend in time with. Because then you can factor that into the non-financial contributions. So you've got a situation in property settlement, and look, property settlement is very complex in family law, and there's no disputing that. Generally, broadly, you've got the 4-step process. You've got the entire asset pool of what you've collected together as a couple. Out of that, you take with the liabilities, the mortgages, the credit cards. You get what we call the net asset pool, okay? Then you apply the financial and non-financial contributions of all the parties. Mum might have stayed home to look after the kids. Dad may have contributed more to the home. Dad may have paid $100,000 or paid all of the home. The third step is any future needs. Do the children have any future needs? Do the parties have any future needs? Does mum have a terminal disease? Does dad have a terminal disease? Do any of them need long-term care? The last one that we come to is called justice and equity, where the courts have to decide whether or not consent orders or orders are fair to each party. Now, you're getting in a situation where you're saying, well, who's little Johnny and little Mary going to live with predominantly? If they're living 50-50, then the property pool, there's an argument to be made, it should be split down the middle if parties have contributed financially or non-financially. So we tend to work up percentages of what each party has contributed financially and non-financially. Then we work out percentages of future needs, and then we take all that information and we reach a figure 65, 35, 45, 55, 50, 50, based upon the factors that have been present. Things like superannuation, somebody might have 500,000 in super, but it's not actually included in the asset pool. It is, but it's treated separately and divided separately. So you may decide somebody's going to get more of the cash and less of the super, or somebody's going to get a lot of the super and just a little bit of cash, depending on the circumstances. If dad needs to buy a home and mum keeps the current home, how much does mum have to pay him out of the home to set him up? That's where it becomes fairly complex. So the answer to your question is, it irritates me when we go to a mediation, even in what we will call a family dispute resolution conference before a judicial registrar, which is the same thing as mediation, and the other side wants to talk about property first. It's just like, no, that's not going to happen. Come on, guys.
You would recommend not to talk about that first?
No. Parenting the children always comes first, because if you
put the children
decide,
first? Yeah.
and look, I recall somebody a few years ago, and look, he told the mediator weeks in advance, we're not going to be talking about property first because we'll be here all day and we'll never get to parenting. Anyway, the mediator goes, well, there's a process and we'll see what happens on the day. And then sure enough, the other side wormed their way into, oh, look, we just need to discuss this instant first, communication and time, communication and parenting apps and what have you. So I spent a couple of hours working on that. And then they got to another subject, which was semi property. And then in the afternoon, it got to the point where, oh, no, too tired now. I've got to go home. Mediation finished without talking about parenting. Oh, and my client was furious, wasted all that time. And look, mediators cost, some of the private ones are fairly expensive. So, you go on there with every good intention to reach a resolution. And when it doesn't happen,
Is there anything in the process of, because we hear a lot about like parental alienation, right? So one parent sort of alienating the other parent against the kids. Is there any way that the court can kind of battle that for the parent who's been alienated against? Because sometimes it can be really fucking clear cut that that's happening.
Yeah, look, and the courts, unfortunately, this is where a lawyer does have to fight, even me, and it's not uncommon to have to stand your ground in some instances. Now, generally, the courts, I've heard at least 4 judicial registrars and a number of judges say to me, Mr. Poed, children walk with their feet when they're 14 or 15. So courts are rather reluctant to make orders for children that old because the wishes of the child are taken into consideration. But that doesn't really fly with my clients and me, because as far as my clients are concerned, well, there's been a serious degree of alienation. And look, my firm tends to take on the high conflict in the alienation cases. To answer your question, the only real thing that we've got up our sleeve in that respect is a very famous High Court case in 2017, 2018 called Bondelmont. Now, Bondelmont was a High Court decision where father or mum had taken the child overseas, and children were 15 and 17, didn't return them, saying, no, children want to stay here. Now, mum applied under the Hague Convention to have them returned. Now, went to the Federal Circuit Court, not sure what they said, but it went to the High Court, and the High Court said, well, look, not going to accept the argument, the children's wishes, because you've got to take into all of the factors of Section 60cc, not just the children's wishes, into consideration in making an order. Really, if you're going to make an argument of alienation, you have to do it from the onset. So generally, if you come to me and the children have been alienated for like the last 4 or 5 years and say, oh, Roger, I really want to get these children back, it makes it very hard for me. So not impossible, but convincing a court that it's in the child's best interest. Now, the problem is the child only has a number of options. One of them, of course, is reunification therapy. And look, if they're so heavily ingrained, the legal world got shocked to its core by a ruling, and I might actually email for your viewers later after this. It was a ruling that came down, I do believe it was somewhere around February. Now, the judge in that matter made very clear comments about alienation. And I read it and I was completely appalled at the outcome, but I understood the judge's reasoning. Now, the story goes that the children were so heavily ingrained of alienation against the mother that the father and the grandparents, they got to the point that they had just terrified the children against the mother, and the children could not spend time with them. Now, the court made a decision. It granted the father sole parental responsibility. The children live with the father and have no contact with the mother. And the court's reasoning was that the children were so traumatized that it would not be in their best interest to spend time with the mother. But the court made a comment, and I can pretty much quote it word for word. It's something to the effect of, the party may think that they're getting a victory, but I can only wonder at the harm that they have caused these children and the likely impact it will have on the children's future. But given the circumstances, ultimately, I can't make any other decision.
The trauma was too
The trauma
hard.
was just too hard. Oh, look, I'll email you that case.
That's interesting.
And look, it came down, I think it was around about February of this year, but I've never seen anything like it in my life. It was a case that was so, and if you read the judgment and you read some of could have included the transcript of the actual trial itself, and it left you flabbergasted that these parents and these grandparents could actually do that to these children. And these children, as a consequence, are now not going to have any relationship with their mother whatsoever.
And it must be shit, like, in the judge's point of view to give a finding like that too, knowing that it's still wrong.
Look,
But
judges, they're only human, like you and me.
yeah, that's what I'm saying. Like, it must feel bad knowing that you have to, on the evidence and the well-being of the kids, doing the wrong thing's kind of the right thing. Or
And look, and the judge felt that exposing the children to any kind of future trauma would not be in their best interest. So he ordered the final order. And look, be as it may, whether or not he made the right decision, one can only wonder. But his logic was very sound. And if you read the judgment, you think, okay, I get that. But that's what happens. And look, that case has been going on for a while, as far as I could determine. But like I said, it's very important that you get in early, because you can do things like reunification therapy, and the court can do two things. Once you get past the age of 10, 11, 12, that's when it becomes kind of, okay, we've got to act quick on that. There's a couple of cases I'm doing at the moment that are in that category where the alienation has been going on for a fair bit of time, and now we're coming up to final trials, and we're running a pure alienation case. And look, I got to say, I'm getting counsel on this one.
Yeah.
Yeah, it is. Some of them are very, very controversial to the extent that you can see what's going on. The courts can see what's going on. But it may be the case that is it going to be more harmful than helpful?
Yeah.
And that's one of the things we have to grapple with.
So many layers, right?
Yeah. But on the flip side, children are resilient, and we've got evidence of that. So it's not unusual to see reversal of care for a 12, 13, 14, 15-year-old under the circumstances, even though they haven't spent time with the other party for a couple of years. It's not to say that they don't know the person. We tend to think that in terms of if the child is something like 2 years old, it's very difficult that they're going to get a reversal of care to the father when they're still attached to the primary mother. But once the children reach school age, 5 years old, that's when things start to become overnight time with the other parent and alternate weekend arrangements, and that stays in place until the child turns 18, generally, unless they want to have more time. But that's the standard. Child turns 5. Argument can be made that if there's siblings, you wait for the younger one to turn 5 and then they both go, or whatever. But that could be an argument too. But talking in terms of, is there an age where the court won't make orders for the children? there comes a point of time when the court will say, "What are you doing, Mr. Poed? Why are we here?" Client's instructions, Your Honour. But that
right.
said, Your Honour does have to take all those factors into consideration. And look, the court quite often has a lot of sympathy in these instances. So I have no doubt in my mind that these courts are looking at it from an unbiased lens in the eyes of the children. And look, there is very clear evidence to suggest that each children should be entitled to have a relationship with both their parents, even though it's no longer enshrined in legislation. Yeah.
It's good to hear that you know it is like we only hear it from one side, but to know that from the experts that it's still deemed as fair. You've just got to know what rules you're playing against.
I think you'll find that family lawyers tend to burn out the most. They stick in the game for 3 to 10 years, and then they either burn out or they move on to another area. You find very few male accredited specialists in family law. It's not a particularly pleasant area of law unless you're that inclined. I enjoy it. A lot of people use it as a stepping stone to get to other lists, but family law is one of those areas where everything is involved. You've got aspects of criminal, civil, contracts, domestic violence, wills and estates even. So that's what I like about family law more than anything. But I do believe that it's time that men start to become more aware of their rights in respect of parenting matters.
Okay, so I got a question. This is from a viewer. Why does a woman who owes child support not get pursued the same as a man would? Would this be like a broad thing, or
Well, I don't know if I can answer that, because you have to understand that child support is in a league of their own.
Yeah.
They are a government body. They make discretionary decisions based upon the legislation. I don't know the stats of who and who doesn't get sued by. Yeah. But look, certainly I've been in situations where both sexes have come to me and say, this is really unfair what I've had to pay. And look, I've got no doubt in my mind that it is in some cases used as leverage by one party or another. Yeah. But look, in terms of whether or not they're getting a fair deal, well, they can always apply for a reassessment, or they can always talk to their local parliamentarian. And look, on that point, very good and valid point, I quite often tell this tip to my clients, and it's worked for me in the past too. When I was in my younger days, if you've got a problem and you go into a police station, you say, "Oh, officer, look at this. They've lied in their affidavits. In Section 194 Queensland Criminal Code, Your Honour." Well, not Your Honour, but Mr. Officer. Guy at the front counter goes, "Huh? Mm-hmm. What? No, I can't help you, mate. That's a civil matter." Well, actually, no. Section 194 deals with false accusations and false declarations and false statutory, false affidavits, what have you. Police fob them off, and then I'll just tell my clients, look, go to your local parliamentarian, talk to them, get them to refer you to somebody higher up in the police service to acknowledge your complaint. So if anybody has any concerns, what they should be doing, if they're not getting the advice that they're getting or the help that they're getting from the government bodies, the police or child support, or they've got a general grievance, write to your parliament, make an appointment, ask them to refer you to it. If there's something wrong, you can do that.
Squeaky wheel gets the grease.
Yeah, and look, that's worked a treat a couple of times. I've had my clients come back and say, "Thank you for that, Roger. That actually worked." I got referred back to the Queensland Police, and the police got back to me within a couple of days and said that they're going to investigate. Beautiful.
Yeah.
Tick, tick, tick.
Nice.
Off I one off?
You fob one off, mate?
It's one from some of the, I don't know what the female herd is, but we'll work out a name. The cat.
The herd.
No, we're not saying the cattle.
Damn. The herdettes.
Jesus, Dean. Come on. So this is probably go both ways, but how to manage a co-parenting situation without a order when the other co-parent is very narcissistic.
Yeah, narcissism is a word that gets thrown around a lot.
Yeah, I was just about to say that. A lot of people don't actually know what the real term in narcissism actually is, but...
Hit us with it.
Yeah.
Well, look, it is actually embedded in the DSM-5. And look, what I've noticed, my own personal observations, is you've got the golden three. You've got narcissism combined with borderline personality disorder and intermittent explosive disorder. You usually find them all combined together. Um, it's not uncommon for a forensic psychiatrist to interview our client on the other side and make diagnoses of one or the other, and all three together, because that generally is what one of those things combined leads to other things. Now, how to co-parent? Well, the first thing I recommend is set up a parenting app. The less communication you have, the better. Get rid of your mobile phone, guys. Don't communicate with your ex with your mobile phones. Get a parenting app, for God's sake, because you are literally throwing yourself back into all of the antagonistic past by looking at your own phone and communicating through there. Separate it. Get a parenting app. Only have that app on another device, not your phone, because you're taking away some of the tension and you're letting go. And you use that app only to communicate for the purposes of the children. Why would you want to communicate with the other side for if it's not for the children? You wouldn't. So don't involve yourself in that situation. If you feel the need to communicate with your ex, then that's a problem that you've got to deal with. But move on. Get a parenting app. Check it every couple of days and have a notification sent to your phone if there's something that has arrived, so you can go, okay, I'll go check it. That's what I find deflates and a lot of the tension between couples for co-parenting. Now, the other thing, if you've got the other side that's really not wanting to communicate or not wanting to co-parent, then your choices are rather limited. You can either go to mediation, and if you can't agree on things, then you go and attempt mediation, and hopefully a good mediator will try and resolve things. If you can't, the only other option is to put an application through the court and ask the court for judicial determination on the matter. Because if the other side is just saying, look, no, don't want you to have a little Johnny this weekend, you're not getting him. Aww. And look, the worst thing you can do is wait and wait and wait.
Just get it done.
Get it done. Now, you have to go to mediation before you file an application for parenting order, unless there's an emergency situation. In an emergency situation, is usually little Johnny's in trouble, or he needs to go to school and we can't decide on his school, or she's taken off to another country next week and I want to stop them from going. I need a watch list order, things like that. All right, but otherwise, get yourself into mediation, make a whole list of all the problems that you've got and what you need to talk about. Maybe give a lawyer a call and say, look, I've got this problem, what should I do? Somebody like me will spend 50 minutes on the phone saying, well, okay, in mediation, talk about this, and this. If you can agree, great. Here's a list of panel of mediators that we use. These are good. Check them out. Send you the links. Pick one you want. And if you still can't agree, the mediator will issue you with a Section 60I certificate, which you put at the back of your application for the Federal Circuit Court. An application will cost you about $575 for interim and final orders for parenting. Now, if you've got a concession card, pension card, it's free. You can waive it. But your application should set out your interim and final orders. Things, when you say can't communicate, well, that's very common. Because like I said, we live in an Australian culture. And we have different perceptions of how our children should be brought up. And you've got to take that into consideration. So as much as she has to look at you and your point of view, you've got to look at things from her point of view. But if it's really the case that she's just saying no to everything, well, then you've got a problem. And just take it to court, seriously. Because if you wait 5 years hoping it's going to get better, the first thing the court's going to say, why didn't you come sooner? And it's too late when the children are 11, 12, because then little Mary's going to be interviewed by a child impact report writer, and she's just going to say, oh, I don't want to live with Dad. He didn't want to spend any time with me at all, so why now? And then you got a problem.
I'm going to follow it up because this leads on to the question that she previously asked is, or what are the suggested legal... oh, you've just done that anyway. But I'll read it out. What are the suggested legal parameters one should put in place regardless of whether an official child agreement is done?
Well, you've got a couple of options here. You've got a parenting plan. If you go to a mediator, or even if you work it out between yourselves, type up a parenting plan which you both sign. Look, believe it or not, that carries weight.
Okay.
It does carry weight. So Typical example, I had a couple who had a parenting plan in place that was signed by both parties for about 2 or 3 years. And then um, she, well, they went to mediation, and then one of them didn't show up, can't remember which one, and then filed in court. And in the court, we filed the parenting plan as the order. And the courts took it into consideration, saying, well, look, you were coping for a lot of years. What happened? So the court does take into consideration the difference between a parenting plan and a parenting order, even if it's by consent, is that a parenting plan carries no legal weight, which means you can't file a contravention for it. But you can certainly put it in your application and say, look, this is the plan. We've had it in place all along. And the courts will take that into consideration and say, well, look, I'm ordering the child to go back to that arrangement because that was working for you guys, and there's no reason why it should have been interrupted. So having a parenting plan is a good thing. If it's not signed, it doesn't make any difference. Just make sure you've got some evidence for that. That's what's been occurring over that period of time. Emails and text messages and things like that doesn't have to be signed, doesn't even have to be written. If it's been going on for such a period of time, just put that in your affidavit to the effect of that's what's been occurring.
It's been acknowledged.
All of a sudden, one of them has decided to take the kid and say, no, you're not getting them. And, can't do that.
Yeah.
Okay.
So,
Solid.
Okay. Next question. How does one go about revoking an order made against you?
an order, a DV order.
Yeah, it must be a DV
Yeah.
order.
Well, DV orders are funny things. There's the really only way to get rid of a DV order. If it's made by consent, it's made by consent for 5 years, unless you make submissions under, I think it's Section 94 of the Act, why it should be reduced. But it's in place. You can file an application to vary a DVA4 to form to nullify it, essentially, down to remove all the conditions. And in those circumstances, the court would invariably not strike it out, but
So remove the conditions, but it's still there.
kind of, yeah, but there's no conditions attached to it. That's really the only way I know, because there's no real discretion for the magistrate to remove it. Now, because it's been dealt with already, so it can't be re-agitated. What can sometimes happen, though, depending on which it was, if it was a private application, both parties would agree, then the magistrate may entertain that and offer and, in law of it, accept an undertaking, even though it's been settled by consent. That can sometimes happen. If it's a police application, good luck.
Okay.
Yeah, you're not going to get anywhere.
Yeah, it's kind of like in NZ, we have like the Clean Slate Act, which is
Yeah.
it says that your file lasts for 7 years, and then you get clean slated. You obviously have to apply to the Ministry of Justice for your clean slate, but really your file never gets wiped.
Well,
Those
no, your
things are
criminal record.
always there. Your
Yeah, but the
criminal
thing about a
record's always there.
DVO is it's not part of your criminal history.
Okay.
So once it's expunged, it generally won't show up.
Okay.
It'll show up on your criminal history as a civil matter if it's been breached.
Yep.
But once it expires, it doesn't carry any legal weight. And you've got to understand that it won't show up on a background search either.
Okay.
Really?
Well, generally, it won't show up on a background search if it's been
So
expired.
that's 5 years, is it?
Yeah, once the 5 years has passed. Now, the only exception realistically to that, and look, these are all discretionary decisions too. There's no real legislation on this, but the general consensus is you can't get rid of a DV protection order once it's in place. You can nullify it down to zero, all the conditions removed, and in that instance, it can be somewhat dismissed. But police weapons are another different category because they're the only exception. You can't apply for a weapons license until 5 years after the DV has been taken away.
So
Yeah, I had a boss actually, and he got into an incident with his wife one night, and he threatened to shoot her horse.
Yeah.
And he went out there with his gun to threaten to shoot the horse. and then
not
the
a very
SWAT
good thing
team
to-
turned up,
Yeah.
and
who
then
would've
he
thought,
got
eh?
arrested, and all of his guns got revoked. and then
Who
he
would
got
have thought?
put through the
Yeah.
courts, and he had to do anger management courses and everything. Subsequently, ended his marriage, and
Well,
and
yeah.
whatnot. But
Yeah.
yeah, I just thought you're a fucking dumbass.
Yeah.
Yeah, and I didn't work for him too much longer after that. To be
So,
fair.
if they take the DV down to 0,
Well, if you nullify a DV,
That's one,
remove the
nullify.
conditions, yeah.
what happens if you do end up doing domestic violence again? Does that go, well, no, see,
Well, look,
does it carry any back charges or anything like that? Or once it's
well,
at
you'll
0?
certainly be taken into consideration if anything fresh
Mm.
further occurs.
Yeah.
Look, but that's only private applications, and generally private applications are treated a lot more lenient. For example, private applications, you can do something called an undertaking. So it's a promise to the court you can hand up, saying, I will be of good behaviour. The difference between an undertaking and an order is that an undertaking is not an actual order. So if you breach an undertaking, the police can't charge you.
Okay.
But it does give the other person the power to bring it back before court and give you an automatic 5-year finding of fact.
Okay.
So, yeah. Now, that only works with a private application. Police application, forget it. And the police are very rarely going to be reluctant to reopen up proceedings again to vary the conditions. Look, if it's a condition such as, want to remove this clause, great, no problem. You can bring that on. But to remove the DVO altogether, it's not going to happen.
Mm.
Yeah, because as you know, the court has to be satisfied as to the third element, whether it's necessary or desirable. Well, it wouldn't be here if it wasn't going to be necessary or desirable. So that's the factor. So, yeah, and look, I've never heard of a DVO being taken away in my career. I'm told that it can be nullified down to 0. I've never seen it in action myself.
If you're obviously proven innocent, then
Well, look,
it could
if-
be nullified.
Well, look, you've got two choices. To make a final protection order, you've got a couple of options. If you're going through the process, and you can at any time before the final trial saying, you know what, stuff this, I'm going to consent without admission. Now, a consent without admission basically means that you're going to abide by the terms of the DVO without admitting any fact. So this is the beautiful thing. And quite often I say to my clients, look, mate, I know you're really innocent, but there's a small chance that you're going to be going to trial in this DV matter, and there's going to be a finding of fact that you've committed domestic violence. Buddy, I would ordinarily not have a care in the world except for the fact that if there's a finding of fact made in this jurisdiction, it's going to have a flow-on effect in the Federal Circuit and Family Court of Australia, and there'll be a family violence order in place, and it'll hold.
So is that similar to what's the ruling where people plead guilty, but
Consent without admission.
yeah, that's what it really is. Okay.
So quite often some of my clients will consent without admission because they can't risk a finding of fact. Now, if you go to a final trial and the magistrate says, yep, okay, I heard all the evidence and I'm satisfied there's a relevant relationship, I'm satisfied that there was an act of domestic violence, and I'm satisfied on this and that date, blah, 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 that happened, and blah, blah, blah. I'm also satisfied that it's necessary and desirable, and there's only a 5-year protection order put in place as of this moment. Now, that's a finding of fact, and you're in big trouble at that point because you've got a finding of fact made, which she can go or he can go running off to anybody and say, yep, he's guilty of domestic violence. Consent without admission means they can't do that.
And that could be just a push.
If the court makes... Look, under Section 8 of the Domestic and Family Violence Protection Act, it lays it out very clear what the acts are. There's sexual, physical, emotional, coercive, financial. Look, the general rule is it's got to be a recent act, and the courts will often say, Mr. Poed, that happened like 2 years ago. Why are you bringing it here now? Oh, Your Honour, because he's scared now. Mr. Poed, grow up. And look, that can happen. So you've got to have a fresh allegation, and you can bring up historical stuff down the track too if you need to. And look, the process in that court is bring an application forward, either you or the police, and then you go to court for the first time, the magistrate will be minded or not to make a TPO. You can make submissions that it shouldn't be a TPO at the point in time. Now, like I said, they only have to be satisfied with the first two elements, relevant relationship and active domestic violence, to make a TPO. They don't have to prove the third one, whether it's necessary.
2 out of 3 ain't bad.
Yeah. So, look, and there's plenty of times I've gone in there and say, Your Honour, why are we here? This is ridiculous. This is happening in the family court. They've brought this on near now as a knee-jerk reaction, Your Honour. I'm asking Your Honour to summarily dismiss this application, or at least let me file an application to summarily dismiss it. What does the other side say about that? No, Your Honour. We want to continue. We want a TPO straight away. Your Honour, you can't have two jurisdictions hearing the same thing. Come on. And the court will allow me the opportunity, in most cases, to allow me to make an application to summarily dismiss the domestic violence application. If a TPO is granted, then directions will follow, which means that the aggrieved has 28 days to file an affidavit in support of their claim, and then the respondent will have 28 days after that. Then you'll come back for a review mention, and then if you still can't agree on whether or not you want to go to a final trial or not, a trial date will be set to hear the matter. That is a general process.
Is the process taken seriously from both sides? So, like,
Look,
if a just for example's sake, if a woman called the police and said, "My husband's just pushed me and I've fallen and hit the wall," police turn up in 15 minutes. If a man rang the police and said, "My wife's just pushed me, I've fallen and hit the wall," is the matter taken the same way
On merit.
yeah.
on merit?
I can give you an example of a case I had, one of my more memorable cases, with a lovely chap. I won't mention any names, but started off with a couple in a relationship, and she ended up assaulting him. He called the police. Well, no, she called the police, and anyway, the police were initially going to put a TPO against my client, and then ended up at the very last minute putting a TPO on against the female. And then, long story short, a couple of videos were posted on YouTube, which my client got a hold of before they were taken down. Anyway, they were the most disgusting ranting and ravings about my client that you could possibly imagine. She withheld the child, as generally does. End result was she got a criminal conviction for assault, and at the end of it, they got a 50-50 relationship with the child. A fantastic result. But the police, it was interesting because the police believed him purely because he had a scratch on his cheek. And I do recall, and I won't say too much, but I do recall at the cross-examination, there were some commentary made about her behaviour, which did not match the reaction she was displaying on the day of her cross-examination.
Yeah.
So
Yeah, I guess my question was just, it was more because it's kind of like, obviously you hear a lot of cases against men from women, but you never generally hear about it the other way.
well,
right?
look, yeah,
But
that's true.
I guess it was just more of like are those cases taken just as seriously?
Yeah, of course.
Yeah.
Well, look,
Okay.
you have to understand that the police culture. Well, I will say there is no real police culture anymore. To be fair, you've got a lot of people of all diverse backgrounds in the Queensland Police Service. So, you've got a whole wide range of people with different beliefs. So, one of them, of course, is people that are coming from some of the more older generations, where they really don't have any preferences between or gender bias. So I've personally seen police do their job really well and look at the evidence and think, well, okay, I'm not going to accept that. I've seen a lot of support from the Queensland Police Service for men, especially, that are very clearly acts of domestic violence, and the men are just simply too afraid to stand up for themselves.
Right.
And the police have had to intervene in order to protect them, even though they don't want to.
And so,
Like, I'm sorry.
No,
I'm,
no.
Like, I'm definitely not trying to take anything away from the fact that
Mm.
obviously more women die every year at
Yeah.
the hand of man than men don't. Well, 0 men have died at the hand of a woman this year, right?
Yeah.
But there's obviously a growing number of women dying because of violence against women. But yeah, I guess it's just an interesting concept because it's not one that often gets talked about,
Yeah.
right?
Well, there's no dispute. The statistics are pretty clear.
Yeah.
More men are the aggressors.
Yes, that's
But
right.
at the end of the day, what concerns me more than anything that may be true, but you've still got 1/4 of the population that still deserve protection, and that seems to be overlooked or labelled as part of that 3/4. So that's the part that bothers me. And at the same time, too, you've got the minority of females who are actually abusers that seem to be overlooked. And and look, I got to
There's definitely
say,
a lot of strong females out there. That's
Oh,
for
yeah.
sure.
oh yeah, I have no doubt.
Yeah.
And look, my experience has been there is a very slow shift, particularly in the last couple of years. I've seen a lot more reversal of cares to men in the Federal Circuit and Family Court of Australia, but I've also seen a big shift in the way that men are being treated by the police. They're no longer, well, they're no longer being there's less few of them saying to me that they're being targeted by the police, as they were saying in my early stages of my career. Nowadays, it seems to me that they're a lot more tolerant of the police. And look, it doesn't take much for me to get on the phone to the police and say, "Yep, realizing you want to have a chat to my client. Just want to know what it's about. Can you talk to me about it?" Diffuse the situation a bit, because I think what happens with men is they get very intimidated by the police, and women tend to think police supporting them more than males do. Males tend to view police as stay away from them.
and they feel like they have to justify themselves then and
Yeah.
there.
Well, I
But the
guess if you've
worst
done
thing-
nothing wrong, then there's nothing to worry
Yeah,
about,
the
right?
worst thing you could do is talk to a police officer. I can't stress that enough, fellas.
Okay.
Just don't do it.
And don't put shit up on social media.
Yeah, that's
Like
another
what
bad
you,
one too.
yeah. Don't put shit up on social
Yeah.
media, especially if you've.
Especially texts, because the first thing I do when I'm looking for information evidence, I'll say to my clients, look on social media and see if you can find anything that's been posted about you.
Yeah.
Even if it's from friends of friends, because we have a provision of the Family Law Act. It used to be Section 121, now it's Section 117. Can't quite know off the top of my head anymore. It got changed about a year ago. It prohibits people from identifying particulars of family law matters. So it's actually a criminal offence to post information about a family law matter or identify parties in a family law matter. So if you're posting texts or social medias saying, "Oh, yep, this, that, and or we're going to court tomorrow, and he's going to take my kid," blah blah blah, then Jesus,
Yeah. Yeah.
Just don't do it.
cringe shit.
Keep it private.
Don't do it. Yeah.
That's a no-no.
So
That's
I
a
do
no.
actually have a fact check for you, Tim.
Okay.
Oh, Jesus.
With women being the perpetrator of homicide in intimate relationships.
Okay.
It is females being the victims is roughly 1 every 11 days.
Mm-hmm.
Males being the victim is roughly 1 every 26 days.
Okay.
Yeah, so the odds
Okay.
and the statistics are fairly clear. I mean, it's not like all men are abusers.
Okay.
Yeah, yeah,
But
and
more than I thought it did.
Yeah.
well, look, I think those stats are going to be increasing as time goes by, because you're living in a liberal environment now. You've got the Aussie culture, but you've also got women that are being incredibly empowered,
Yeah.
and that is a good thing.
Yes.
But with that comes that, I'm going to do what I like now. So, especially with the attitude that's been put out by the courts, is that, well, children deserve to have a relationship with both parents.
Yeah.
And look, I know plenty of cases where that's been prevalent, where that's been utilised with that attitude. No, my kid, my way, or the highway.
Yeah, that shits me. It's my kid. It's like, no, it's not. It came from me.
Yeah. I mean, obviously, it's just something that you've got to talk about.
Yeah.
You know, when you are in those really long term relationships. But yeah,
Got to
yeah.
put that hatred aside and, yeah, at the end of the day, think
Yeah,
about,
oh man, you know,
hate me in private. That's fine. But, you know, don't deny your kids of a chance of
That's right,
having a
that's
good
right.
relationship.
yeah,
Yeah.
and I do, you know, I do applaud the parents who do
Hmm.
sort of, you know, do the right thing by the kids, and it's you know, about the kids. Like, you know, like my parents split when I was really young, and I don't really know what went on behind the scenes. I know that I got to spend every second weekend with my dad, and you know, my mum was a primary care. Um, my dad worked in construction, so he worked very long hours. So it would have been very hard for him to have some kind of 50-50 arrangement. But there was a time when I was 12 when I left my mum's house and I wouldn't live with my dad. And I remember him saying that he hadn't paid child support for a long time, so he was having to backdate all these payments and whatnot. And I couldn't quite understand it because I was living with him. I didn't understand why he'd have to be paying the child support, but it was because he hadn't paid it for so long. You know,
Caught up.
they're caught up. Yeah.
Well, look, I think that communication is the key. If you
Yeah.
can get to the point where you can communicate, then everything's really there.
Everything's there. Yeah.
There's no, everybody's got to give and take in
Yeah.
a separation. You know
Yeah.
what I mean? What we do know is that children take it especially hard, and their scars are going to be there for life, and they're always, they'll learn to deal with it, of course,
Yeah.
and they're very resilient. But
Yeah.
It'll be there.
yeah.
Yeah.
And look, there are a lot of support networks out there. You've got so many other options than to go to court, because the last thing you want to do is spend money on legal fees. Do it if you have to,
Yeah.
but I mean, sometimes there's no other option.
That's
But
right.
I
Sometimes
mean,
that can be messy.
yeah,
Mm.
yeah. And look, I tend to deal with the high alienation cases and the high conflict and the urgent ones. I enjoy doing them. But the majority of cases are ones that can be resolved by going out and having a cup of coffee with your ex-partner and saying, okay, what do we need to do here?
Yeah.
You can still hire a lawyer. On that subject, please don't do a BFA, a binding financial agreement. Please do consent orders.
Okay. What is a binding financial agreement?
A binding financial agreement is a private agreement between two parties. Exactly the same thing as consent orders, except that they're done by lawyers instead of the court. Now, you still have to go through the same process, which is, you know, the four-step process: getting the disclosure documents, and then determining what your client's worth, and then equaling out and trying to figure out a split, making a split, and then you've got to provide a letter of advice to your client. That's a BFA. If you do it in the Federal Circuit Court, you fill out the forms and you still get lawyers to assist you, but it's filed in the court and it's stamped by the court as an actual order. So one's an order, one's a private agreement. The reason why you should go through consent orders with the court is because it's usually quicker for a start, and it's more thorough. I mean, you've got to do your due diligence and making sure that you are getting a fair deal. More importantly, it takes the pressure away from the parties and the lawyer to be held responsible for justice and equity. The court takes over that burden for the fourth aspect by stamping on the steel, saying, yep, I've considered it all and it's just and equitable, which means the court's looking over it and making sure that everybody's getting a fair deal. In a BFA, that's less likely to happen. Solicitors are good,
Yeah.
but you want the satisfaction of a court having looked at your material, a judge that's been up there for a long time and saying, yep, that's just and equitable.
Yeah.
Child support agreements are different. You've got binding financial child support. You can make a private agreement. Don't recommend you do that either. Go through the agency. It's going to be a lot easier, in my view, and it's less hassle down the track, because to overturn a binding financial agreement is a lot more difficult down the track than it's worth.
Yeah.
Part and
Yeah.
parcel.
So, parting words, Roger. Parting words. What do you got? What-
Look, ultimate aim is to keep out of court as much as you can.
Yep.
You really have to know your education. Don't talk to the police unless you really have to. If you're being served with documentation, don't help the police make their case. Best words are no comment. Yep, my name is so-and-so, but no comment. Anything further? Nope, not coming down to the police station with you. So sorry. Want to talk to my lawyer. If they're still hassling you, start recording your phone. Yeah, it's legal to record in Queensland as long as one party is privy to the conversation, and that comes under the Invasion of Privacy Act. So, perfectly legal to record police. They're recording you, so why not record them?
They're a public servant.
That's exactly right. So, it's always good to have that assurance that it's happening the way that you allege that it happened. In terms of parenting matters, same deal. Go and see a lawyer. Find a lawyer that fits you. Don't pay for a consultation. Contact a few lawyers beforehand who offer free quotes or give you a half hour, an hour of their time, just to give you some advice and give you a pathway. Because you may find that somebody sounds really good when you're paying them $550 for the consultation, but then, no. At least you've got the benefit of having to go to and shop around for a number of lawyers before you decide on one that's right for you. Okay, and that's sensible. There's plenty of them out there that will give you free consultations. Okay, even if it's only 15 minutes, and find one that gels with you. Yeah. Otherwise, that's all I've got.
Yeah.
Mate, I've never listened so hard with my eyeballs.
Yeah. Yeah. No, well, I think I think tonight's
That is an
episode
amazing episode.
will have a lot of will help a lot of men out there.
Yeah.
Women also. And I just want to make it known that if you are going through any family domestic violence or any domestic violence, 100 would be your first port of call if you are in danger.
That's exactly right.
Then you got domestic and family violence support, which is 1-800-RESPECT. For men, you've got Men's Line Australia. You've got No to Violence, Men's Referral Service. Queensland specific, DV Connect Women's Line and DV Connect Men's Line. So look those up, get those numbers if you need them.
And if you do need help, call Roger.
That's right. Now, we're going to leave all of Roger's details in the description below so that if you do need to reach out to for a family, you can give Roger a call.
Thanks, guys.
And this has been episode 52. And it's been a pleasure having you
pleasure.
on, mate.
Pleasure's all mine, buddy.
Mate, that was a ripper.
Thank you so
Absolute
much for taking the time to
man,
come
I've
and
learned
sit with
a
us.
lot.
Yeah.
Lot.
I'm going to have to listen to that episode
Yeah.
a couple of times, I think, to absorb some of that information.
I think I'll listen to this one.
I think you should.
Yeah.
And I think
All men should.
if
women.
you've got any comments, if you've got any questions, if you've got anything else you want to add in the comments, do that. Remember, you can find us on Facebook, TikTok, Instagram. Our streaming platforms are Spotify, YouTube. Drop us a review, drop us a follow, subscribe, all those good
That's
things.
the one, mate. Not LinkedIn yet.
Not LinkedIn yet.
No,
Nah.
it's there, but
Yeah.
we don't.
But yeah, we will have
I
all.
avoid LinkedIn.
Yeah, we'll have all Roger's details in the description below. Thank you very much. Peace out.
Real talk. We're putting it all on the table. You know what to do.